damages, then that's when you start looking at insurance policies and assets and things of such. Kelly, we live in a no-fault state, and we've been harping on why uninsured motorists is very important, okay? But because we live in a no-fault state, we have what this, I shouldn't say nasty word, but we have PIP. And I think we're the last state in the union that probably has a version of PIP insurance in the whole country. So out of 50 states, we're I guess 49 have it wrong and we have it right. But we're working really, really hard with our Congress, our Senate and our House over in Tallahassee to try to get this changed in the next upcoming sessions. But that's what we're stuck with right now. So explain to our viewers what PIP insurance is and what does it pay for?
PIP insurance pays for your medical bills, 80% of your medical bills up to $10,000. And it also can pay for when you work loss, wages loss, and that sort of thing. So it's what they make you pay for to protect yourself, and it's our version of not making people carry the bodily injury insurance. So it basically just says, okay, nobody has to carry that, but you have to carry for yourself the personal injury protections. And
we commonly refer to our state as a no-fault state. So no matter who's involved or who is at fault in an accident, your own insurance company is going to pay first, and they're going to start paying those PIP benefits. Now,
it's the primary.
One of the things that slipped into this legislation and this I guess this insurance statute is if you don't get a emergency medical condition diagnosis within 14 days of an accident, your benefits go from $10,000 go down to $2,500. And so if you've been involved in an accident, please make sure that you seek medical attention.
Get seen by somebody.
And at least if you're fine, thank the Lord that you're okay. But at least if you have some concerns and are not recovering like you think you should, you still have preserved your benefits there. Phone lines are open, 850-392-1544. You can always email us at lawcall@wmbb.com. And we do have our first email question of the night from Mary. 2 boys on my street do yard chores for me and my neighbors every summer. But they've gone from simple jobs to lawnmowers and weed eaters, and last year one almost stepped on a snake. Am I liable if one of them gets hurt in my yard? How would you handle this, Mary? Well, Mary, I think every good snake is a dead snake. So I feel I understand your concern there.
You and Jim both.
Yes, but Kelly, you want to take a stab at that, and how would Mary handle that?
Well, if one almost stepped on a snake and they didn't actually step on the snake, then there's probably not a cause of action here. But that even still, yes, if somebody's in your yard, you have homeowners insurance. And so your homeowners insurance is going to be responsible for folks that come in there, especially if they're young boys who are doing this sort of thing. If it was a professional lawn service, they would be licensed and bonded, and they would take care of their own most likely. But your homeowner's insurance would probably kick in and take care of any injuries.
And so if you have an injury on your at your residence or at your property, you have med pay, which is basically a short word for medical payments, and that coverage provides benefits to anyone that is hurt on your property, with whether or not there's any fault or not. Now, stepping on a snake, there's probably not going to be any fault on the part of a homeowner unless you have pet snakes and they're venomous and you know about it and you don't tell someone that they're roaming around in your yard and confined and creating a dangerous or hazardous condition. But, typically speaking, if someone gets injured on your property at your home, there's a low-level coverage of insurance that will provide some benefits there to someone for some medical coverage. But beyond that, when you're talking about negligence, Mary, unless you have a concealed hazard that's known by you to be on your property and unknown to those young men that are working on your property, and you feel like that concealment of that hazardous condition would cause a dangerous injury to them or cause any type of injury to them, you could be on the hook for negligence. And so if you're negligent in informing them that you had a dangerous condition on your property or a hazardous condition on your property, well then yes, your homeowner's policy could be liable and they could seek compensation for their injuries. Now, if it's someone and you just say that they are cutting grass and they just get injured from no fault of anyone, well then attacking that homeowner's policy is probably a little harder. So
that's true. But you would be, yes, you could possibly be liable, but your homeowner's insurance would step in and take care of you. So most likely you would not personally get sued, hopefully.
We do have another email question from Sean. And I believe Sean has a question about a car accident. Thursday night I was hit by a truck that ran a red light. My car is destroyed. I felt okay at first, just in shock, but I can't hardly move now. What do I do next? I've never been in a wreck before. Well, Kelly, that's That's personal injury 101 right there. So we got Sean involved in an accident, and we've got a negligent party running a red light. So now his PIP's going to check.
First thing you need to do is obviously you need to get checked out by a physician of some kind, whether it be a chiropractor or just your regular personal physician or whomever. I was going to say a minute ago when we were talking about PIP and seeing a physician within 14 days. Oftentimes you don't feel terrible at the very beginning, and you progressively kind of get worse as your body sort of locks in on itself when you've had some sort of, even if it's just a soft tissue injury, you can get locked in on yourself, and so as the days go on you get worse and worse and worse. So it's not uncommon that you felt okay at first because of the, like you said, the shock. However, that is not necessarily that you are okay. We get that a lot, don't we, Chris, where they say, oh, well, he said he was fine at the scene. Well, he may have been fine at the scene, but as time goes on, you get worse. So the first thing you need to do is you need to make sure you get seen. You need to also report the accident to your insurance company, both your auto insurance company and your health insurance company, and you need to seek legal representation. All of those things need to happen about as soon as possible, truthfully. As soon as you get a lawyer on board, they will also send out letters of representation to all of these folks, put everybody on notice, and you need to find out what's going on with the other party's insurance and your own insurance.
So Sean, what Kelly's also referring to is, seeking legal representation. You need to get someone who advocates for you. We take it, or I think a lot of people take it for granted, that they're hoping that they're going to get better. They're hoping that they can put a lot of this behind them and they can get back to work. Well, on the back end, on the opposite side of that, an insurance company is sitting there evaluating you and hoping that you do go back to work, and hoping that you don't file a claim, and hoping that they can reach out to you and pay you a small nominal fee for your injuries, because they're trying to get to you before something manifests and makes worse and gets worse. And so they actually have someone advocating for them behind the scenes, and they actually have lawyers on staff that do nothing all day long but look at auto injury cases or any type of injury cases and give them advice about what they should do and how they should handle their cases. Now, they have claims adjusters, Kelly, that are very, very seasoned, so a lot of times those claims adjusters could be as smart or smarter than the lawyers that are giving them advice, but they do have somebody advocating for them, protecting their position. And so, we always tell our clients, shouldn't you have someone advocating for you and level the playing field and have someone that can kind of go to bat for you and make it fair to talk to these insurance companies? Because Kelly, you said something that was very important. At least in the Panhandle, we try to rub some dirt on it and get better.
Absolutely.
And we make statements sometimes of, hey, I'm feeling better, I'm doing okay, and an insurance adjuster, as they're speaking to you, are taking down all of those notes.
Absolutely.
So by all means, find an attorney who specializes in personal injury practice, Sean, because you'll have somebody advocating for you. And if it was our firm, the first thing that we would tell you is, do not speak to that insurance company anymore. Let us do all that, and you do one thing, and that's get better. So phone lines are still open, 850-392-1544. You can always email us at lawcall@wmbb.com. We're going to take our first break of the evening, and we'll be back in just a moment. Welcome back to Law Call. I'm attorney Chris Young with the law firm of Perry & Young, and I've got one of our attorneys with us, Kelly Roberson. She also works for us as well. And we're taking your calls live, all about injuries. And if you've got a question, give us a call, 850-392-1544. Or you can always email us at lawcall@wmbb.com. And I do believe during the break we got another email question from a Rick. And Rick, my ex-son-in-law recently crashed his vehicle with my 7-year-old grandson in the front seat unbuckled and 4-year-old granddaughter in the back seat unbuckled. He claimed it was due to the fog. However, the kids were not in the right place and restrained. Can he face charges because he only received a ticket and his CDL being taken away? So, Rick, you have a lot of things going on right there, and at least let's put the criminal aspect aside about facing a ticket and the 7-year-old and the 4-year-old in the front seat and the back seat. You know, if they're, I pray that they're okay, number one. And if they're not, if they do have any type of injuries from this accident, and it's a little tough because a 4-year-old has a hard time articulating, you know, why they hurt and where they hurt and how bad it hurts. And a 7-year-old is a little bit better, but about the same. But you need to watch them very, very closely and make sure that they're getting seen by their pediatricians and any other type of physician that they've been referred to as well. It's very hard to, you know, do any type of manipulations with a 4-year-old and a 7-year-old from a chiropractic standpoint. So I'm sure there's some diagnostic testing that will be coming their way just to rule out any type of injuries that they may or may not have, just to be on the safe side. Now, a 4-year-old and a 7-year-old cannot be held to the same standard as an adult. So if they're unbuckled or restrained, if they were a 40-year-old and involved in an accident, and even if it wasn't their fault and they were not wearing their seatbelt, there's some part of comparative liability there that would be forced on or given to them, and so they would be responsible for some of their injuries. Now, a 4-year-old and a 7-year-old, that same analysis would not apply to them. So whatever injuries they do have, even though they were unrestrained, it would not be counted against them in the event that you're trying to make a claim for their injuries. Now, the more pressing question of what you have, Rick, is what to do with your son-in-law, who is apparently maybe an idiot and not, you know,
taking good care of your grandchildren.
Buckling down a 4-year-old and a 7-year-old and letting him sit in the front seat without a seatbelt on. Let's just say, for sake of argument, that it really was fog. Well, that's why you have seatbelts, especially for minor children, because it protects you from any type of incident that is out of your control or under your control. So, you know, if he was drinking and driving, obviously he did that to himself and ran off the road. He was, you know, he's to blame for his injuries there. Fog, things happen, road conditions, and let's just say he couldn't handle it and he obviously he had an accident. Well, shame on you, but that's still negligence, okay? So can he lose his CDL and should he be charged? Well, unfortunately, a civil attorney cannot file charges against I guess just a civilian. You know, anyone who's doing civil practice like a personal injury attorney cannot file charges against them. That would be left up to your state attorney, and the state attorney would have to look at that to determine whether or not criminal charges were, you know, should be imposed on him. Now, if your 4-year-old or your 7-year-old had more significant serious injuries, and I don't know if they do or not, but assuming that they did, well then that would maybe compel a state attorney to press charges against your son-in-law,
potentially child neglect,
for child neglect and being responsible for their injuries on a criminal side, not only just a civil side, but a criminal side. So, you know, the fact that he has a CDL, he should be held to a higher standard, and that may play into the analysis from the state attorney. However, you're at the mercy of whatever the state attorney chooses to do. And so, Kelly, you have little girls, and now thankfully they're off in college and they're not 4 and 7 anymore.
Right. But
I'm sure you'd be just as angry as Rick was if they were and that was your situation.
I would be very, very upset if somebody was not taking good care of my children and making sure that they were properly buckled in. That's the adult's decision there, not the kids. Yeah. So if they're hurt, he's liable.
Yeah.
So
now, Rick, another component of that is you may want to make sure that if he's paying any type of child support to your daughter, if he loses his CDL, you may be getting your pound of flesh, but at the same time, you may win the battle but losing the war,
Absolutely.
because if he loses his CDL, then maybe he can't provide for your grandchildren anymore, or maybe pay some type of child support or alimony. So you may want to weigh that versus pushing it. But you go back to, you know, the 4-year-old and 7-year-old, Kelly, they would fall under the PIP statute, no matter if it was, you know, the son-in-law's fault or not. But you would also file a claim against his policy, you know, for if he has bodily injury coverage, right? And then you look to the famous uninsured motorist, and that's why it's very important. And that analysis that we just spoke about 15 minutes ago into the show plays into this very importantly, because if, you know, your children are in with someone else, they're still covered up under your policy. Correct. And it could be a resident relative with Rick if they're living with Rick also. So there's multiple policies to look at there. But Rick, I hope your 4-year-old and your 7-year-old grandchildren are okay. But at the same time, you know, be careful with how you approach your son-in-law and what you think that you should, you know, how far you want to push that, because you could be opening up Pandora's box. And if he's just an idiot, which it sounds like he could be, he may be a good father who's trying to pay for you know, child support and any alimony to your daughter. So if he loses his job and loses his CDL, that may be a more damaging and damning effect than just you know, seeing him go away. But Rick may be very upset with his son-in-law, and this may not be the first time. This may not be the only thing that Rick is upset with. But Rick, I do appreciate your question.
Thank you.
And thank you for emailing in during the break. Phone lines are open, 850-392-1544. You can always email us like Rick did, and Sean earlier at lawcall@wmbb.com. Kelly, you know, what happens when you go out of state and you get involved in an accident?
Your coverage follows you from state to state to state. There's some exclusions in terms of different countries, and it just depends on your policy. All the policies say something different. Some of them have exclusions for Guam or whatever, so other places, but you just have to look at your policy. But if you leave the state, your insurance follows along right.
But we'll follow with you, and if you are in an accident and you're out of state, your uninsured motorist will follow you also. But if you also leave the state and you cause an accident, like Kelly said, your insurance will follow you as well and protect you from anyone trying to file claims against you, or at least up to the coverage limits of your insurance policy. We're going to take our last break of the evening. We'll be back in just a moment. The phone lines are still open to take a quick call or email, 850-392-1544. You can always email us at lawcall@wmbb.com. Be back in just a moment. Welcome back to Law Call. We're in our last segment of the evening. And Kelly, anything you want to?
Absolutely. We've talked to these folks a couple of times tonight about going and talking to one of us lawyers and finding out about their insurance policies and all that sort of thing. But we haven't explained to them how we get paid. And so I don't want them to worry about how they pay us. We actually work under what's called a contingency fee basis, and what that means for you as the person that comes in to speak to one of us is that as long as we don't make any recovery of any kind, you don't pay us anything.
Right.
And you really don't pay us anything straight out of your own pocket, because anything that we get is going to come out of the insurance company's pocket, not yours.
So you only pay us if we collect for you. So a contingency fee is contingent upon us recovering for you. And you know, Kelly, that's really important because we talked about earlier in the show leveling the playing field, and you know, it's hard for individuals to balance everything that just life in general. Then they get involved in an accident and have to worry about hiring an attorney and not understanding, you know, how do I pay for this individual? And so, you know, that's one of the great things about a contingency fee is we get paid at the end of the case when the client gets paid when we make a settlement for them. So there's no out-of-pocket expenses, and lo and behold, something odd goes on and we don't recover. Well, guess what? They don't owe us anything. So we're about to wrap up. We're down to the last few minutes of the show here. We're in our shout outs. Kelly, got anybody that you want to give a shout out to?
I want to say hi to my mom and dad. They're trying to stay up to watch me tonight, and my husband Jim.
Hey Jim.
Hey Jim, and Shelby is at home as well, but Stevens is over in Tallahassee, so I'll say hi to them anyway.
All right. Well, I have a slew of them here. I've got my wife Ashley is watching. I've got the boss man's probably snoring with her in bed, but I don't think he's watching, but I'm gonna give a shout out to him anyways. My mom is watching. Trace Smith, Judy Smith, Rick over at the Bar and Grill. Pam, Miss Pam Myers is watching on Facebook stream. Thank you, Miss Pam. The Buck, my nephew Mason, Paula Frederick, and Scott Heitzman. Scott with a K.
Scott with a K.
Scott with a K Heitzman is watching tonight. And
corn dog concierge.
The original corn dog concierge, and you could find him on a billboard on what's that?
Highway 98.
Highway 98 there at the foot of the bridge, and you can always, you know, just text him for your first five free corn dogs. So, anyways, thank you for joining tonight. Law Call, as usual, we're here to take your questions and calls live. If you have something come up during the week and you need to reach out to us, feel free to email us at lawcall@wmbb.com. Same time, same place next week, and I hope you have
or call our office.
Call our office, but also have a happy Easter next Sunday.
Yes.
Good night.